Okay, it's 11:30 by my clock, 11 o'clock for most everyone else online. So we'll go ahead and get started. For those of you I haven't had the opportunity to meet, my name is Andrea Williams, and I'm a lawyer in our St. John's, Newfoundland and Labrador office. Joining me today is Ryan McCarville, and he is a partner in our PEI office. So we're very pleased to be speaking to you today about pay equity and pay transparency, and we'll hopefully provide you with some guidance as to your legal obligations, as well as some best practices for employers moving forward. It's quite timely that we're speaking to you about this topic today on the heels of International Women's Day this past Sunday. I was actually scrolling through social media Sunday night, and I came across a post that said, it's ironic, I guess, that International Women's Day fell on daylight savings time, giving women one less hour in the day to celebrate, and it's very 75 cents on the dollar. So I thought that was very fitting for our presentation today, and made a mental note that it could be my opening joke. So that's, well, 75 cents on the dollar is really a US statistic. That's not to say that pay disparity doesn't exist here in Canada. We're not quite 75 cents on the dollar, but according to a BC report in 2024, the gender pay gap still exists. Atlantic Canada actually is ranked relatively well compared to the rest of the country. New Brunswick was about 94 cents on the dollar, Nova Scotia 93 cents on the dollar, Newfoundland and Labrador was 83 cents on the dollar, and Prince Edward Island was very close to parity on the dollar. So the wage gap is closing, but in all reality, it should be equal, right? There should be no wage gap. So that's not to say that there's not work still to be done or room for improvement. And that's what pay equity legislation really tries to address. It's bridging that gap in gender disparity and for the pay difference in jobs that are typically female dominated versus male dominated. I see we have a hand up already. We're going to do questions and answers at the end. Just I'll pause there for some housekeeping. There's a question and answer function on the side. So if you want to type your questions in the box, we will have a time for questions and answers at the end. In the meantime, if there's any technical issues, just raise your hand and we'll do our best to help you. So picking back up, pay equity legislation really does try to take a proactive approach to bridging that gendered pay gap. So what we hope to do today is to provide you with the legal framework of pay equity legislation, also highlight some other legal obligations with respect to pay equities that employers have, and then provide you with some best practices going forward. We'll also talk about pay transparency and employers' obligations around that, and employees' expectations in the changing workplace. So what is pay equity? What do we mean when we say the phrase pay equity? At its core, pay equity simply means equal pay for work of equal value. So it goes a step further than equal pay for equal work. I think it's pretty clear that if you have a man and a woman sitting side by side, working the exact same job with the exact same responsibilities, the exact same role, most employers ought to know that they should receive the same, and it's pretty obvious for employees to know, equal pay for equal work. What employment equity tries to do is go that step further. So equal pay for work of equal value. So it really looks at jobs that are traditionally male-dominated roles versus female-dominated roles, and looks at the value that they provide to the organization. And are these jobs being valued the same financially and in terms of compensation? So in case law and literature on pay equity, we sometimes see the phrase, it's not apples to apples, it's apples to oranges. And what this means is you're not comparing two identical roles, but you're comparing two similar roles. Apples and oranges, they're both fruit, they both have nutritional value, they both are easy to pack as snacks, involve minimal effort to eat. And so you can see how you have that comparison of what value do they provide to the organization. A more realistic example would be a human resources advisor, and an IT specialist. They're quite different roles, but they each require a specialized skill set, independent judgment. In many organizations, they have similar hours, similar work schedules, and there might be similar time-sensitive demands, confidentiality requirements, etc. So pay equity legislation is really designed to look at the type of work involved and what value it has to the organization. Why does this matter? Well, first of all, it helps to address the systemic wage disparities that exist in the country. So, like I said at the beginning of the presentation, we're getting closer to closing that gap, but it still exists. And in different jobs and different workplaces, the gap can vary. Also, it promotes workplace fairness. So this is something that employees are well aware of, and employees are becoming, I would say, increasingly aware of their rights in the workplace. And with that comes pay equity, pay transparency, and then that ties into when an employer does promote pay equity and does have a robust plan in place, it does foster higher workplace morale and retention. So looking now at the legal requirements, pay equity obligations can arise in a variety of different legal frameworks, the most obvious of which is pay equity legislation. So pay equity legislation generally takes a more proactive approach, but largely targets public sector employers. So rather than waiting for an employee to raise a complaint, hey, I think I'm being undervalued in the workplace, what pay equity legislation attempts to do is um, require employers to adopt a proactive framework to evaluate their jobs, determine what the value of each of those jobs are, and put a plan in place to address any wage gap. Of course, there are exceptions to all of these provisions. Obviously, if there are different skills required, seniority, if this is a particularly hard to recruit role, pay equity legislation often contemplates those exceptions. So it's not just a blanket requirement to adjust salaries within your organization. So it is important to be mindful of those exceptions as well. So looking to Atlantic Canada, all Atlantic provinces do have some form of pay equity legislation. However, at the moment, this legislation only applies to public sector employers. So what that means is if you're a private sector employer, you do not have any strict requirements under pay equity legislation as it now stands, but we are seeing a move and a trend that more private sector employers are starting to adopt pay equity plans, and that governments are now starting to amend legislation to also apply to private sector employers. So New Brunswick, the government of New Brunswick has indicated that it intends to expand its pay equity regime to the private sector. These changes have yet to be tabled or come into force, but when I checked yesterday evening before this presentation, it is very much still on the horizon. So New Brunswick employers, it's important to be mindful of that. And if you are able to take proactive approaches, a proactive approach to pay equity before that legislation comes into effect, you'll be well positioned when the time comes. So if you're sitting back and thinking, okay, great, I'm in Atlantic Canada, I'm a private sector employer, the hook. That's the case. It's just in terms of a formal pay equity regime, the pay equity legislation only currently applies to public sector employers. But as we'll talk about a little later in the presentation, there are still legal obligations for private sector employers as it relates to pay equity. Take a moment now and talk about the Federal Pay Equity Act. This is a fairly new piece of legislation. It only came into force in 2021. And in my opinion, it is perhaps the most robust pay equity regime in the country. It's like all federal employment legislation. There are lots of nuances for federally regulated employers to comply with, but it does apply to both public and private sectors. So federally regulated private sector employers rather with 10 or more employees are required to comply and have a pay equity plan in place. There are a number of requirements under the Federal Pay Equity Act, including establishing a pay equity committee. The composition of that committee is also dictated by legislation. I believe it's 2/3 of the committee must be female or female identifying. If you have a unionized environment, there must be a unionized union representative on the committee as well. And then the pay equity committee is required to go through the process of classifying jobs, reviewing, assigning a value to those jobs, and then drafting a pay equity plan that must be posted in the workplace. So typically the steps in making a pay equity plan involve identifying and defining job classes, determining whether those classes are predominantly male or female dominated, and then evaluating the relative value of each job. And that's really the difficult or complex part of this analysis. So it's looking at factors like what skills are required, what education is required, what's the effort required for each job, what's the responsibility, is it a supervisory role, is it a safety sensitive role, what are the working conditions, and then comparing the value of that job to the other jobs in the workplace or the other job classes in the workplace. So this legislation came into effect in 2021. The deadline for federally regulated employers to have a pay equity plan in place was September of 2024. So if you're a federally regulated employer and you don't have a pay equity plan, the deadline has passed, but based on my understanding and experience with the pay equity legislation, I don't think you're alone on that. There are penalties for noncompliance, including monetary penalties, but to our knowledge, there has yet to be a penalty under the Act. Employers were really only required to file their annual statements in 2025. So if you are not yet compliant, there's still time, but it is important to be mindful that it is a requirement for a federally regulated employer if you do have 10 or more employees. I also want to touch on the Ontario pay equity legislation, knowing, of course, that the majority of you operate within Atlantic Canada. I will touch briefly on this piece of legislation, but this is one of the oldest pay equity regimes in the country. I believe it came into force in the 80s, so good on Ontario for being proactive in attempting to close the gender gap. But this legislation is a little more complex in that it applies to both public sector and private sector. However, the responsibilities for private sector employers varies depending on how many employees you have. So if you have, I believe it's 50 or more, you're required to have a pay equity plan in place. But regardless, all employers are required to put plans in place to achieve pay equity. So what that means is a little unclear. Many employers, I assume, have pay equity plans in place to comply with this requirement, but you are not technically required to go through all the requirements under the legislation of a pay equity plan. So it's a little different, and pay equity legislation varies, of course, from province to province or federally as well. I will say, as we see the trend shift towards pay equity requirements for private sector employees, it'll be interesting to see what regime is the predominant requirement for employers. Is it going to vary like Ontario, or is it going to be that robust system like the federal regime? So we will be keeping a close eye to New Brunswick for that, because I think they're going to be the next one to adopt a regime for private sector employers rather. So stay tuned for that, and we'll certainly be keeping an eye on when that legislation is tabled. So as I mentioned, pay equity legislation is just one part of an employer's legal requirements to recognize and achieve pay equity. It can also arise in a number of other different forms, predominantly through human rights legislation, also labor standards acts as well. But as you can see here from the slide, every Atlantic province does have a Human Rights Act, and pay equity is protected by that. PEI and Newfoundland and Labrador are provinces that do have established provisions in their human rights legislation that expressly prohibits pay discrimination, and that's based on protected grounds under the Act. So that even goes a step farther than gender disparity, and if there's any prohibited ground under the Act that a person feels that they have been discriminated on based on their compensation, they're entitled to make a claim under the Act. Brian's going to speak on that a little further and actually discuss a case done by one of our colleagues in Newfoundland and Labrador to help demonstrate that pay equity very much is something that employers ought to be aware of. It's something that can result in human rights complaints, but also what is an employer required to do in determining pay equity and defending against a claim of pay discrimination. So again, human rights legislation and employment standards legislation do prohibit pay discrimination based on sex. I will say that this is a complaints-driven process. So human rights legislation, employment standards legislation, it's reactive in nature. It's based on individual complaints for employees. You as an employer are left to respond to that complaint and defend against it. Whereas pay equity legislation is more proactive in its approach. So what has an employer done to eliminate those barriers, whereas human rights legislation looks at, are there any barriers? So if looking at what can an employer do in practical steps to defend against any claims of pay discrimination under the Human Rights Act, I think a good starting place would be looking at pay equity legislation and taking those steps towards having a pay equity plan in place. While you're not strictly required under pay equity legislation as a private sector employer, it would certainly help defend against any claim of pay discrimination if you have gone through those steps, evaluated jobs, assigned a value, and taken steps to eliminate any wage gap. So as I mentioned, I'll turn it over to Ryan, who's going to speak about the Connolly case from Newfoundland and Labrador and speak a little more on pay transparency. Ryan, over to you.
Hey, thanks, Andrea. Welcome, everyone. Glad we're able to make it to this presentation here this morning. As Andrea said, I'm going to be talking about primarily pay transparency, but I did just want to tie a bow on Andrea's presentation and talk about a case. It was a human rights case out of Newfoundland in 2022, so somewhat recent. And when it comes to pay equity, as Andrea said, the legislation primarily applies to public sector employers. So there's no standalone legislation in Atlantic Canada that applies to private sector employers yet. So your risk when it comes to pay equity or failing to pay employees equal pay for equal work is really under the human rights regime. And we see that in this particular case. So in this case, as Andrea said, we had a couple colleagues in our Newfoundland office actually represent a union, which was a bit unusual for our firm. Usually the union's on the other side of the file. But in this particular case, the union was actually operating a training facility. And that training facility was training students to work in operating heavy equipment and mobile cranes. So this employee was employed up until 2016 and then filed the human rights complaint in 2018, so after her employment had ended. It's unclear from the decision how she ultimately learned that she was being paid less than her male colleagues, but in any event, she did learn that she was being paid less than her male colleagues and filed a complaint under the Newfoundland Human Rights Act. And as Andrea said, the Newfoundland Human Rights Act, as in PEI as well, has a standalone provision that prohibits discrimination or paying an individual less than other individuals in that same role on the basis of a prohibited ground. So the Newfoundland legislation states that an employer shall not establish or maintain differences in wages between employees employed in the same establishment who are performing under the same or similar working conditions, the same or similar work on jobs requiring the same or similar skill, effort, and responsibility on the basis of prohibited ground. And then it makes exceptions for seniority system or a merit-based system. So this employee ultimately discovered she was being paid less than her male counterparts and filed a complaint under the human rights legislation, and it went to a hearing. I'll go to the next slide, Andrea. And so to succeed under the language of this provision in the Human Rights Act, the employee or the complainant had to establish that she worked in the same establishment as the male colleagues. Well, that was easy. They were in the same facility. She had to establish that worked under the same or similar working conditions, performing same or similar work, and in jobs requiring the same or similar skill, effort, and responsibility. So ultimately, the adjudicator looked at, well, what was the employee actually paid, and what were her male counterparts paid, and what did the job actually entail in comparison to what her male counterparts' job was. And the adjudicator noted there was certainly some overlap in the duties and responsibilities of her position vis-a-vis the male counterparts, but there was sufficient sort of distinction from her role to her male counterparts. And in particular, she had no education, training, certification, qualifications, or work experience specific to heavy equipment or mobile cranes. And the respondent also argued successfully at the hearing that the pay difference was because it was necessary to pay the amount that they paid the male workers because they were skilled in the operation of heavy equipment and mobile equipment. So this female complainant did not actually train students in the field on operating heavy equipment or mobile cranes. Her role was focused more on the classroom setting and lesson plans. And so for that reason, the adjudicator ultimately dismissed the complaint and found no discrimination. You'll see up on the screen there are some of the reasons why the adjudicator found that there was no discrimination in this particular case. The adjudicator said, concurred with the position of the respondent that the positions were not substantially similar. Unlike the complainant, both, I've redacted the employee names, but employee A, employee B are required to be in the field, handle heavy machinery during instruction, clear snow, perform ice control, perform some maintenance of the equipment and facilities, and they're also responsible for equipment startup and shutdown. And then the adjudicator went on to comment on other differences in the roles as well. So ultimately, this complaint was not successful. The employer had a valid rationale for the pay difference, but I think the lesson in this is that there is a risk of a human rights complaint if you are not paying some workers the same as other workers that are doing the same work, if they have the same training and skill and experience, and in particular if the employee that you're paying less can establish a prohibited ground under human rights legislation, so on the basis of sex, gender, a disability, and the other grounds of discrimination. So if you are paying employees differently, then certainly it's important to have a valid rationale for that if they're doing the same work. So with that, I'll get into, that sort of concludes the pay equity portion of the presentation, and we'll talk about pay transparency. I do want to give a reminder as well for the Q&A. We received some questions beforehand today, which we will answer or try to answer everything throughout the presentation and at the end, but certainly if anything pops up, just enter a question into the chat and we'll do our best to answer it at the end. So pay transparency. So as we said, pay equity is focused on equal pay for equal work. Pay transparency is, as the name suggests, being transparent or open about wages or salaries in the workplace. And the goal of it is to level the bargaining power between an employer who holds all of the information and an employee who has very little information or certainly or no information about what other employees are being paid. We have pay transparency legislation here in PEI. It's under our Employment Standards Act, and it's been in place here since 2022. And it was introduced in 2021 by a Green Party MLA. And I just want to read briefly her comments when she introduced the bill in the legislature. She said, "We're all familiar with the concept of equal pay for equal work. This has been the law in PEI for decades through the Human Rights Act, which prohibits discrimination in pay. However, despite these protections, island women and other demographics continue to receive compensation that, in many cases, is not equal to that of men." Then she went on to say, "Jurisdictions across the globe are implementing and expanding pay transparency requirements as a way to close the gender pay gap. Through adoption of pay transparency measures, governments seek to prevent employer practices that disadvantage workers and seek to improve bargaining power of workers, particularly women and other disadvantaged groups, in negotiating for better wages." So that's ultimately the goal, is to put some information in the hands of employees so that they can sort of level out the playing field in terms of the bargaining power between the two parties. The Green MLA went on to cite the European Commission as well in introducing this bill, and said that a lack of information on pay levels across organizations, sectors, and regions/countries discourages workers' mobility and contributes to horizontal gender segregation. So that's really the goal of it from a legislative standpoint, but so it's really focused on workers and sort of evening out that power imbalance. But as you'll see through this presentation, that's not all bad for the employer. There is some benefits to pay transparency for the employer that we'll talk about. Go to the next slide there. So in preparing for today, I did a little bit of research, including some social media research, and came across this website. And this website is called Salary Transparent Street. This woman has about 1 million followers on Instagram. And what she does is very simple. She goes up to people on the streets in various cities in the United States and asks them what their job is and what they make. And sometimes she'll ask, "Are you satisfied with what you make?" And I'm sure she gets rejected by many people when she's out on the street, but she also gets a lot of interviews, and people are very willing to share their jobs and what they make, and sometimes their thoughts on what they make. And to me, this, and she isn't the only one doing this on social media, but certainly I think it shows that society has shifted in their views on sharing salaries. And it may have shifted because of the laws have shifted in recent years, but I also think that workers realize that sharing this information is actually beneficial to them. If workers can get the information out there of what other people make, then they will be more informed in terms of their being able to negotiate a better salary. So, maybe it used to be taboo to talk about pay and what you're making with other employees, or even publicly to 1 million followers on Instagram. But it is not as taboo as it once was, if at all, anymore. This is I should warn everyone, this is a very addictive website. You could spend hours going through her clips. It's very interesting to hear what people's jobs are and how much they make. And in the interest of transparency, she herself shared what she made in 2025 in one of the clips, and she made $1.2 million. So it certainly made me rethink my career, because she, going up to people and talking to them on the street and posting those clips, earned her quite a bit of money. So anyway, it's all interesting, but again, it just shows how society has sort of shifted in terms of sharing information publicly or with coworkers. So we'll go to the next slide there. So what does pay transparency measures look like? They're a little different in each province, and some provinces have announced it and haven't quite rolled it out yet. But generally, it comes down to these three items. The first is banning questions from an employer to an employee as to what they made, what their salary or wages were previously. So you can't, in PI, you can't ask a candidate what did you earn in your past job? And of course, the tactic that employers used to do, or some employers anyway, is that they would get a job applicant. They would ask the job applicant, well, what did you make at your previous role? The applicant would disclose that, let's say 60,000. The employer would then say, great, how about we give you 65,000, 62,000. So slightly more in order to attract the candidate and satisfy the candidate that they would be getting a raise from their previous role, but perhaps it's less than what the job is actually valued at. And so that would save money for the employer at the end of the day. That has been prohibited in PEI and some other jurisdictions that have adopted pay transparency legislation. You can't ask candidate what their past wage was or what. The next is protection for wage discussions. So in PEI and other provinces, you cannot prevent an employee from talking about how much they make. I have seen, prior to the PEI legislation coming into force, I had seen some employment contracts. It was rare, but some employment contracts that had a specific clause in them saying, employee, you can't talk about your wage. If you do, that's disciplinary and can lead to termination. Those provisions of a contract are obviously now unenforceable and cannot be included in any contracts, and you can't retaliate or discipline an employee from talking about their wages in the workplace. And then finally, perhaps the biggest concern I heard when PEI adopted this legislation was around the mandatory salary disclosure. So employers now have to, in their public job postings, include the pay or the expected pay range from the position. And I heard many concerns from employers when this was being implemented in PEI. There was concerns that, well, if we post a job, our current employees may realize that they're being underpaid, and which was exactly the point of the legislation. But also, there was some concerns that would then lead to a number of departures, or that they would have to, in order to attract other employees, kind of pay more than they're currently paying. And ultimately, I did not see those concerns come to fruition. There wasn't giant exoduses from workplaces or employers going bankrupt as a result of this legislation. And in fact, some employers really benefited from doing that, because by actually posting the pay or the pay range, they were actually able to attract other employees, because many employees may not apply for a job if they don't see what they would make in that job. So employers that were previously not including any salary or pay range on their job postings could get more candidates, because candidates would see, okay, this is what I'm going to make in this job. I know what I'm signing up for. And so they can attract better candidates. In terms of the concerns around losing employees, my advice at the time was the legislation allows employers to put a range of expected pay in the job posting. And so if you want to attract if you have an employee making 50,000 and you want to attract a new candidate with 80,000 range or 80,000 pay, then you could put on the range of your job posting 50 to 80,000. You're currently paying that position 50,000, and maybe to get someone experienced in the role, it's going to take more. And so your current employee would see that they at least fall within the range of the job that you're posting, and that higher range may attract a new candidate. But certainly there was many concerns when that legislation was being rolled out, but I think overall I've not seen many of those concerns actually come to fruition. Go to the next slide. And in fact, as I said earlier, there's benefits to pay transparency. when this legislation was being rolled out in Ontario just recently, CTV News went and interviewed employers, and many of them talked about the benefits that they saw in pay transparency legislation and disclosing wages to their employees. According to some employers, those employees have improved satisfaction because they know that their employer is being transparent. They feel like their employer is being fair with them in providing the wages that they're providing, and it builds that trust between an employer and an employee. I also have on the screen there efficiency in hiring practices. As I said, employees, you may, as an employer, get more applicants to a job because you're actually posting the salary that for the position. So rather than go through the hiring process and the employee not really knowing what the wages are for the position, they know up front, and they may apply because of that wage. And you're attracting the right talent as well. And you're also saving time through the process because you're going through the process with the employee or the applicant knowing upfront what the job is worth, rather than discovering that after the interview process, and maybe that breaks down because they're not satisfied with the amount that is being offered. So it's not while these laws were designed to equal the bargaining power to some degree between an employee and an employer, there are benefits to an employer as well. So in terms of the actual legislation, some provinces have implemented or will be implementing separate pay transparency legislation, while others have simply amended their employment standards legislation to provide that pay transparency laws. So in PEI, there is no standalone legislation. It was an amendment to our Employment Standards Act. And as I said, here in PEI, as well as other provinces, the employer has to include a salary range in the public job posting. So that doesn't apply to help wanted signs, but if you're posting a job with details of the job, then you have to include the salary or salary range. Again, you can't. Employers are not to request compensation history from applicants, and they can't discipline employees or terminate employees for talking about their wages in the workplace. Nova Scotia is in the process of developing pay transparency legislation as well as standalone legislation. It has gone through first reading, and there is no date set yet on when it might be implemented. It largely mirrors the PEI legislation, but in addition to that, it provides for employers that are of a certain, it provides for employers to collect information for the purpose of preparing pay transparency reports. And those reports must be submitted to the governor and council in accordance with the prescribed by the regulations. The legislation does not yet have regulations that detail what is to go in those reports. So it'll be interesting to see how onerous that reporting obligation is in Nova Scotia, and if the government pursues that through this legislation or not. So that remains to be seen. In Newfoundland, it has a standalone legislation, although the pay transparency portions of that legislation are not yet in force, but the pay transparency provisions do mirror or are very similar to the PEI legislation as well. It also provides for pay transparency reports that comply with the regulations. There are no regulations, so similar to Nova Scotia, it remains to be seen how onerous that reporting obligations are in Newfoundland. New Brunswick, as Andrea said at the start of the presentation, they have announced pay transparency legislation. We are all waiting to see what that looks like. I imagine it will mirror what is in the other Atlantic Canadian provinces in terms of posting wage expected wage range and prohibiting an employer from disciplining or retaliating against an employee from talking about their wages. But it'll be interesting to see if they have a reporting obligation similar to what's in the current bill in Nova Scotia and the legislation in Newfoundland. Go to the next slide. Ontario also has pay transparency legislation through their employment standards legislation, and that just came into effect in January of 2026, so this is just a couple months ago. So under that legislation, employers with more than 25 staff must post salary or expected range of salary on job postings. They went a step further than the PEI legislation in that their range cannot exceed $50,000. So you can't in Ontario, you can't post a job that has a salary range of $40,000 to $100,000. The legislation prevents that. There's no such provision in the PEI legislation preventing that. The exception to that, though, in Ontario is unless the higher band is $200,000 or more, then the gap in the pay range can be greater than $50,000. The Ontario legislation is unique as well in terms of artificial intelligence disclosure. So if employers are using artificial intelligence in the hiring process or as a tool to assess applicants, then that needs to be disclosed on the job posting as well. And then finally, in Ontario, there's an obligation to follow up within 45 days with employees who you've interviewed for a job. So you have to follow up in writing or in person to provide them with the decision, with the hiring decision, because and that's to prevent situations where an employee goes through a job interview and is waiting to hear if they've been hired, and the employer just doesn't get back to them. So that is that's legislation in Ontario. I should have mentioned as well in Nova Scotia. So the Nova Scotia bill has been introduced, but in the meantime, before that legislation takes effect, there is transparency provisions in the Labor Standards Code, and those pay transparency provisions are at Section 57A and 57B, and they prevent an employer from asking an employee about their pay history, or an applicant from their pay history, excuse me, and it also prohibits employers from disciplining employees who discuss their salary in the workplace. So we're nearing an end here to the substantive portion of our presentation, but I just wanted to, for those of you who are in New Brunswick and Newfoundland, who are sort of in a bit of a wait and see position here with the legislation, and kind of waiting to see what this ultimately looks like in New Brunswick. It's worth going through the exercise now in terms of how you're going to adapt to this legislation. Like in New Brunswick, currently there's no obligation to post salary ranges in your job postings. And so that's going to change once this new legislation takes effect. How are your current employees going to react? Are you market for your positions that you're going to be posting? So it's important to do your homework in advance of the legislation to determine kind of whether you're going to change your salary ranges, how you're going to determine what is market rate for a particular position. So there's certainly some work that can be done in advance of this legislation so that you retain your employees and can attract new employees as well. And then when the legislation does come out, I recommend employers periodically review job postings of other employers and in particular competitors. See what they're posting for their jobs, and so that you can figure out if you're on market or not. That's everything that we had in terms of the substantive portion of the presentation today. We have left some time for questions. Did you have anything to add to what I said, Andrea?
No, I think we'll touch on most in the question and answer period again, but I think pay equity and pay transparency really go hand in hand. Certainly pay transparency allows perhaps people that have been undervalued in the workplace to realize that they may not be receiving fair compensation. So I think with the increase in pay transparency legislation, you're going to see perhaps more demands or claims under pay equity provisions and human rights claims. So it may be important to be, again, proactive in having a pay equity plan or an approach to pay equity in the workplace. So there's one question online. Do you foresee other Atlantic Canadian provinces adapting to posting pay ranges? Ryan, if you want to, I think you answered that in your presentation, but if you want to address that question more directly.
Yeah, so certainly the legislation has been proposed in Newfoundland and Nova Scotia and is coming in New Brunswick as well at some point this spring is what we've been told. And I think that legislation is going to mirror what is in PEI right now, which is an obligation to post pay ranges for the position. It'll be interesting to, so the current legislation does not include the limit on the pay range that Ontario has. So Ontario has that $50,000 limit, that the gap in the pay range that you post can't be greater than that unless the position is for greater than 200,000. It'll be interesting to see if how this legislation changes, or if it does, to include that type of limitation. It'll be also interesting to see whether there is that reporting obligation that is currently in the proposed bill in Nova Scotia, and what's in the legislation in Newfoundland, which is not yet in force. What is that reporting obligation going to be? I know in PEI initially the minority party at that time, the Green Party, was contemplating putting reporting obligations in the legislation, but ultimately took those out. And I think the legislation, does that, like, protects workers to the extent necessary, and the reporting obligation may just be additional red tape or additional work for employers. And so we'll see what that reporting obligations look like, if any.
I'll also add to that, while you may not see, or you may see provinces adopting pay transparency legislation, what you also might see as the workforce is becoming increasingly transient and remote work becomes, it is now here to stay, and employers are looking to recruit in other jurisdictions. If employees have an expectation that salaries will be posted, it may not be a legal requirement, but it may be a requirement in order to stay competitive and attract individuals that have that expectation that the salary range will be posted.
Yeah, of course, even though some of the pay transparency laws don't apply in your jurisdiction now, you can move forward with them because we know the legislation is coming. And as Andrea said, there is benefits to that as an employer.
So the next question is, can you discuss the need to go through a pay equity exercise in an organization with a formal job evaluation system, which has been endorsed as compliant with pay equity legislation? So I'll try to answer that in pieces as best I can. I think the first step is to really assess, does pay equity legislation apply to me as an employer? Am I a public sector employer or a private sector employer? Because what the analysis would look like will look really different depending on whether or not you are required to comply with legislation and what piece of legislation you are required to comply with. I will say having a formal job evaluation system is excellent. Even if you aren't required to specifically have it as part of a pay equity regime. it will help to defend against any human rights complaints on pay discrimination, because you do have that system in place, so you can demonstrate to a human rights tribunal, we have evaluated each job in an objective measure. That's not to say there might be some indirect discrimination there, but it is very much a step in the right direction to showing that the jobs have been evaluated. We've had this endorsement as being compliant with pay equity. So it would be a strong defense against any complaint under human rights or labor standards.
I see another question in the chat. What's your advice when employers ask to include language in an employment contract that requires employees to keep their compensation information confidential? So my advice is certainly different now than it would have been pre-pay transparency laws in PEI. I would tell the employer in PEI that that type of clause is unenforceable because it's contrary to the pay transparency provisions of the Employment Standards Act. I would also tell the employer that employment contracts are heavily scrutinized by the court. And even in jurisdictions where there may not be no pay transparency laws, including that type of clause in an employment contract may cause a court to even more heavily scrutinize your employment contract. And it could call into question the termination provisions, and I would have concerns about including that type of clause in an employment contract. I have rarely seen that type of clause in an employment contract, and do not include it. Certainly don't include it in. I've never included it in my template contracts or contracts that I prepare for employers. So I would just really caution employers before including that type of language, because I think even if you're in a jurisdiction where there's no pay transparency laws yet, they are coming, and that type of clause is going to be invalid at some point in the near future because of those laws.
Next question. When male-female pay gaps first became public in the federal public sector in the 1990s, we believe, the employees involved were all unionized. It has always struck me as odd that a union would not insist that employees doing the same job would be paid the same. Do you feel the federal government and the union share responsibility for the egregious pay gaps that were allowed to run through multiple CBAs, collective bargaining agreements, that were negotiated during that era? Well, that's a weighted question.
That is, yeah. I don't know if
as employer counsel, where we can share responsibility with the union, the answer is always absolutely. But I do think, looking at the collective bargaining regime, it is very much, a joint responsibility to ensure that employees are protected, that they're being paid fairly. At the end of the day, the party that's going to be on the hook under human rights legislation in terms of compensation would be the employer. So while the responsibility is shared, I think it is important as an employer to be proactive in your approach to pay equity, because it's as much as there's a bargaining responsibility on the union, the responsibility ultimately rests with the employer under pay equity legislation and in large part human rights legislation as well. Ryan, do you have anything to add?
Yeah, I would just say the pay equity and pay transparency obligations that we're talking about here today, they don't apply less to public sector unionized workplaces, but they're less, I guess, affected by them, because the pay, like collective agreements, set out what certain positions are paid and based on certain steps and classifications. And so the pay information is all in the collective agreement in any event. It's not some secret that the employer is hiding. And so, at least for unionized positions. So a lot of what we talked about today will apply, has had a greater impact on private sector employers than it does on public sector unionized employers, minus the reporting obligations under the pay equity legislation.
And I will just add to that from a pay equity, at least from the Federal Pay Equity Act perspective, the Act actually does contemplate a more active role for the union as well. If you're required to have a pay equity committee in place, there is a stipulation that at least one member of that committee has to be a union representative. So it does contemplate, and the idea is that the union will be more involved in that process. Ryan, there's one question that was submitted early that I would fall to you, I believe. Has there been one consistent, unexpected, or surprising change in practice or policy that companies have had to make after implementing pay transparency measures?
Yeah, I saw that question in advance as well, and I wouldn't say any surprising change in practice or policy. As I said during my portion of the presentation, there was a lot of concern there was some concern, I should say, when the legislation was first proposed around including that pay or expected pay range on the job posting. But I would say overall, I think there was some surprise by companies of the benefit of doing that in terms of the applicants that they were getting and in terms of the efficiency through the hiring process that they achieved by being upfront about what the job was worth.
Okay, I think we have one more question left, so try to answer that one quickly. How could the province regulate pay equity in private businesses if that's even possible? Is pay equity the problem or the result? So the province does have jurisdiction to regulate business and impose obligations on employers for reporting and developing pay equity plans. As I mentioned in my portion of the presentation, we've seen that pay equity legislation does apply to private sector employers federally and in Ontario. So there is a precedent for that. Is pay equity the real problem or the result? I think the answer is both. I think what pay equity legislation attempts to do is fix the problem, right? Is take that proactive approach to trying to narrow that wage gap. Perhaps the wage gap is the real problem, but hopefully the solution would be the pay equity regime and being more mindful of pay discrimination in the workplace.
Okay, well, we're towards the end of our time here, and I don't see any other questions unless I'm missing anything. Andrea, do you see any more?
I think we've answered them all either directly or in our presentation, but if there's anything else, do not hesitate to reach out to us.
Yes, we want to thank everyone for attending this morning. We hope you enjoyed the presentation and had a few things to take away from it. And please join us again for our next webinar.